Good, whatever, afternoon, evening, morning. I hope everybody's well. Greetings. Hello. Little dance there. Hope everybody's having a good Saturday. I should adjust my cap. Hope everybody's having a great Saturday. We're going to do today, we're going to do a video or a live stream about GTII to all of you out there. Hope everybody is good. I received a not just me personally, but there was filed yesterday another report by the receiver. I think it's the 7th interim report, which is a compilation of a bunch of other reports. I did a live stream a couple days ago after summarizing what I had filed and kind of expecting something to be filed. And here we go. A few days later, they filed their report to present to the new judge. So figured what I'd do today would be kind of go over some of what was said and ask your assistance or dissent as to certain things that are said in the report to see if you agree with what was said or you disagree, because it might be valuable at some point in time in future hearings. So before I get to all that, so what I'm going to do is what I had a legal software kind of look through the report and make a summary. So we're going to go through that. Then I'm going to go through some individual pages of the report, and then I'm going to ask you some questions, and then I'm going to take your temperature, and then we'll go from there. Before we start, of course, we wanted to, whoever we is going to, as I do every live stream now, I use Claude for its most important purpose, the jokes. And I actually thought today's jokes are pretty good. It didn't require much more direction on my part. But let's go over. Since audit is has been an issue, I asked Claude about audits, and so here we go. It's these are pretty short and sweet, so we're going to go pretty quickly. But I think as a group, I'd have to say Claude is getting better. This just my opinion. So the first thing I asked it to do was give me 6 fantastic short jokes about bad audits, and you could throw in the name Borgers if you want. So here we go. Borgers didn't just miss the red flags, they billed the client for not seeing them. An auditor's opinion is reasonable assurance. Borgers offered vibes. Borgers' audit work papers were so thin, the SEC filed them under fiction. What's the difference between a Borgers audit and no audit at all? About $14,000. My auditor said the numbers substantially agree with themselves. That's when I knew he trained at Borgers. And last but not least, in this set, and I have one more set, Borgers performed 1,500 audits a year. Turns out the trick is skipping the audit part. And if you know the history about Borgers, that makes sense. So after those fantastic jokes, I asked it, those are good, but make 6 more biting and numerous but short and can be puns. So here we go, running through these. Borgers, putting the audit in fraudit. Their engagement letters should read, abandon all assurances, ye who enter. Borgers didn't sample transactions, they sampled fonts. Going concern, Borgers wasn't going to concern themselves with anything. Materiality threshold at Borgers. If it fits in the shredder, it's immaterial. Borgers offered a new service tier, unaudited, but with signature. Their quality control was a spell checker. Gap, Gas, and Borgers, 2 standards and a rubber stamp. Borgers' idea for professional skepticism was doubting they'd get caught. And last but not least, they called it a risk-based approach, the risk being entirely on shareholders. Anyway, I thought those were pretty good. I think it's the best set from Claude that I've seen so far, certainly as to auditors. So I got to give props to Claude. So as I indicated, what I did was I received the report. I glanced at it yesterday, I think, when I received it. Probably spent about 214 seconds looking at it. Then this morning, I took it, I put it through some legal software. I said, give me basically a summary in 3 pages. And I figured this way, whoever wants to get out of here quickly, they can. Otherwise, then I have the individual parts of the actual filing. It's not too many about the filing, and I had some questions. And so feel free to hang in as long as you want or otherwise. So basically, the receiver consolidated all the reports, at least the way they're presenting it. They consolidated all the reports into one and gave the current status and their going plan for what they're going to do, emphasizing amazingly, emphasizing the audit and potential transactions. How do you like that? The receivership, it tells you about how it was initiated, and what the objectives are. Then it talks about audit status and issues and plan, and it says the receiver's paramount focus is completing PCAOB audits for the years 2023 and 2024 and bringing GTII current and SEC reporting to normalize market trading. Let me stop there. Originally, it was going to be 2022. I don't know why 2022 is not there. 2022 was done by Borgers. The reason why originally they said the 2022 and 2023 was because Borgers did both those audits. In light of the fact we still haven't got a complete audit because something is amiss, why would you not want to do a PCAOB? So basically a qualified audit for 2022. Why not? What's the rationale? Is it just monetary? You can't afford it, and whose fault is that in terms of managing the funds? But I don't really understand why the 2022 year, which was in there before, is now somehow doesn't have to be audited by a appropriate auditor. Raise concerns to me. I'm going to continue. They kind of distinguish now about what they call GTII. So it says GTII remains an SEC delinquent filer with trading previously suspended by the SEC on February 2nd, 2024 due to disclosure concerns and filing failures. The audit firm history and serious deficiencies all occurred, or a lot of it occurred under prior management. So they focus on, and I'm going to get to it specifically, but they focus on like there was a prior auditor and he got bounced. I guess he lost his ability to do audits. Then there was somebody else. And then there was Borgers and they got bounced. And then there was Fortune. Oh, woe is me. Now they say they're blaming the prior, seems to me, they're blaming the prior for not having properly managed the audit process. Especially in light of that, I would think that they would have been more diligent and careful in managing the audit process thereafter, knowing the history of the audit process with this company. So by them passing the blame to prior management, which seems to be consistent with whatever they've done in this case, they've blamed it all on others, not their own. And again, this is all my opinion, by the way. So you feel free to disagree with what I say. This is just my opinion based upon my. Now, I think I have a good. I definitely could be wrong. My opinions could be inaccurate. So far, I think they've been pretty good, at least on this matter. But it's not just like I'm not have a source of knowledge. I've been involved with it for quite some time. I've been involved in the legal matter. I've spoken to lots of people, so I feel comfortable when I'm talking about this stuff. So the fact that they claim prior management, I think, cuts both ways. Perhaps some of it is blame on prior management, but that should put you on notice that you better do things perfectly because it's a problem area. And again, my concern here is why, when the audit became such a problem area, didn't they hire a real auditor, like a Big 8 accounting firm, a real professional accounting firm to do this, not some small firm. Doesn't make sense because and obviously it was the wrong choice because we haven't gotten done. So it blames the prior. Then it goes to Barton, and it says basically, and you'll see in the report when I get there, basically it says Barton, that was the catastrophe, and when they quit, and that's the biggest change, etc. Now they don't deal with it. You will see in the report, they don't really talk about why they chose Barton, why they skipped Integrita, why they didn't leave when the first auditor at Barton couldn't finish, why they didn't know all the timing. They don't really address that. They just kind of leave that blank. I guess that they didn't have anything to answer, or else they would have done it. By the way, they say just so we know, Claude says that the receivership was initiated at the request of shareholders led by White Rocks Holding and Richard Hoffman to address alleged insider looting and restore lawful operations. I didn't add that. That's what Claude said. So thank you, Claude. Claude and we go back a long way. We're pretty tight. So the print they say, and again, I'll read it when we get to the point. So they blame prior management. They then blame Barton. Then they blame the delay on the gold transaction and associated debt accounting. Now he's raised that, but he's also raised in open court, he being the receiver, hundreds of transactions. I thought it was 1,500 transactions, something on that order. Whoever else listened to the court hearing heard it also because it was an open court. But hundreds of transactions. He didn't identify those as gold transactions. I don't know what the transactions are. So besides the blame it on bad prior management, Barton is also blaming the slow conclusion on the gold transaction. And now he's saying that they can deal with that by derecognition conditions. Now, I have no idea what derecognition conditions are, although I was wondering all along, if you don't get sufficient evidence to prove something, then it proves something else. So I didn't understand why they just weren't making determinations that if you can't prove it, then it doesn't exist. Sounds like derecognition might be that. I have no idea why it's took them 2 years. I don't know who's doing the derecognition. I don't know how long it's going to take. I don't know how, etc. But they somehow have come to figure out that they can do something. I don't think it's something that just happened. No explanation as to why they couldn't have done this in the past. But apparently, and again, anybody who's an expert in derecognition conditions, that's what they're apparently going to do as to the GTI gold transaction. And that supposedly, and of course we've heard supposedly before, that supposedly is the last obstacle to completing the audit. Now, do I believe that? Not really. Honestly, I don't believe that at this point in time. And why would I believe that if they haven't shown us an engagement letter? As a matter of fact, they say, at least the way I read the report, they say they're asking the court for permission to engage Intrastat, the company in Boca Raton. Now, they've already done that before. That's already been approved. They already went to court after that, and they had with their face in their hands, they had to I think it was the last hearing. They had to indicate that we still don't have an engagement agreement with these guys. So I don't know why they're asking again. All it is, it makes no sense to me. If you got approval before, you got approval before. I heard you get approval before. I heard you then a following hearing admitting you didn't have a signature. And it wasn't the receiver, it was Bill Knowles, who was there because the other attorney was, I think, at a conference somewhere else or was unavailable. And Mr. Knowles took that particular hearing, but it's clear there was no completed engagement agreement, because if there was, they would have had a corporate filing by now, because that's what's required to be done. And even in the report that was, I guess, filed yesterday. And by the way, these points I'm going to reply to the report, so these points will be addressed again, so that the court can hear whatever, putting the report in proper context. But it was clear that it was multiple transactions. So I don't understand the gold part. And again, just it seems to me it's just another doesn't explain why it's 2 years in. I looked at the report. There's no explanation why it's 2 years in. This is kind of complicated. Again, this is not like auditing Tesla. This is a company which they even admit had very little income. They say there's some income. I don't remember, but certainly there's nothing in the till right now. So they claim that the GTI gold transaction that they had to write off, that's what's the last transaction, the last issue. Again, do I believe that? No, I don't believe it at this point in time until it's proven to me, and then I will discuss it. Then it says the receiver plans to engage Integrit CPA for approximately $200,000 to complete the audit using Barton's work papers and existing reconstructions. Now, Barton was paid about $55,000. Their estimate was $165,000 for the 22-23 audits. And this doesn't include the 2022 audit. It only goes, according to the receiver, the 23 and the 24 audits. Now, he said that they were going to complete all the audits plus the 2024. This is my recollection in court. He said or suggested they were going to do 3 audits. Now they're saying they're not going to do 3 audits. Again, it's not consistent with my recollection. And if anybody else heard when the receiver was talking about in court about the Integrit was going to do was going to do the old audits plus the 2024. Was it your understanding that we were talking about 3 audits or 2? Because it certainly sounded like 3 to me, but now it looks like 2, and for $200,000. So is that plus the $55,000 paid by Barton, plus whatever they paid to Fortune, plus whatever they paid to their forensic accountant expert, who's done, I don't know what he's done because they haven't really explained that. Anyway, so that's what they say, that they're going to engage, but they already said they were going to engage. They already said they were in process of getting an engagement agreement, and that's why they had to acknowledge before Judge Williams they hadn't. So I think that's kind of misleading to be at best. This is what they say. There's no DTC chill or global lock on GTI's shares. The live impediment is delinquent SEC status with Rule 15.2 C211 compliance planned alongside an OTCB uplist when current. So they're basically saying, I think, it's not really English to me, but I think they're saying once they can get the audit done, that they can get it trading again somehow. I think that's what they're saying. Now, why they haven't gotten the audit done doesn't make sense to me, but that's what they're saying. The receivers intends to seek a court order addressing the GTII gold situation to enable derecognition and to fund successor audit engagement at the estate level. I don't know, that's not really English to me, but you got to figure out a way of paying for it. Now, I think, if I recall, it certainly was intimated that the receiver would be able to raise money to pay for the audit, not to give away the company to do the audit. And when we get to the end, that's what it sounds like to me. Again, that's if you want to be like super critical. I'll give you the company if you can do the audit, pay for the audit. That's what it seems like a transaction he's suggesting is adequate. And I'm going to get to it. He says he has set out and just think about this. When I get to the after, think if you agree with this. It details a concrete successor auditor plan, identifies a single gating technical issue, and outlines a motion for court relief to resolve this, which addresses audit completion concerns. We haven't even started the audit. We don't even have a firm that's doing an audit, and they're talking about completion. The receiver documents the absence of market structure impediments and presents whatever efforts to secure a business transaction. The receiver identifies 3 active tracks. So here we go. This would be new information. I'm aware of some of this, not aware of all this, and I'm going to go through it in detail so you'll have a better idea. The receiver identifies 3 active tracks requiring court approval. The AI-Versity merger, and I think Forrester said they hadn't spoken to him in months. So how is that active? Whatever. These titles kind of bother me because on more than one occasion now, I think they give a false impression. Like when it says an active thing, active like there's something going on, or active because they're not dead or not officially dead. If it's just they're not officially dead, then that's accurate as being active. If there's actually movement towards completion, then they're not active because there's nothing been done. Haven't seen anything discussed about that. So he then goes on. Okay, then so I have to mention all 3 deals here. So 3 active tracks: the AI-Versity merger, Trento recapitalization. So Trento was originally it was something else. Now it's it's whatever it's specified here. It's only what is public. I don't know what's not public. But a deal in which, in essence, GTII would get recapitalized. In other words, my understanding is money would come in or other assets would come in to recapitalize, and then there would be some other business that would come in also to make it some kind of going concern. But I'll read it how it's referenced here. So AI-Versity references a non-binding term sheet contemplating AI-Versity holders receiving about 91.9% of post-closing common and all Series B super voting preferred, leaving GTI shareholders about 8.1% based on illustrative 34 million, 3 million valuations. Closing conditions include resolving disputed shares, canceling legacy Series A preferred, and ensuring sufficient authorized common, potentially via increase or reverse split. AI-Versity's request that the estate pay $250,000 of its legal fees is deemed untenable by the receiver, and additional issues cast doubt on legitimacy and appropriateness. So that's how they describe the AI-Versity deal that they describe as active. Then they referenced Trento recapitalization. Trento proposed a 50 cents a share recapitalization, effectively requiring issuance of nearly all outstanding shares with structure and viability in question. And again, this is from the receiver's report. This is not what Trento would say. Trento has not provided a bona fide bank proof of funds for an asserted $2.5 million non-refundable fee. Forensic review raises doubts, and no MOU will be executed absent proof and viability. Now, am I aware of this proposed deal? Yes, I'm aware of this proposed deal. Have I participated in any of the negotiations? No, I have not participated in any negotiations. Have I seen any proof of funds? I have seen something that purports to be proof of funds. Was it in the amount of 2.5 million? That's what it purported to be. So I don't know if that was insufficient for the receiver. I don't know what forensic review raises doubts means. I don't know what specific concerns the receiver has about the proof of funds. I don't. Um, and I don't know what they intend to do. Was told by those people, as Forster indicated before. I think he's indicated also in X or whatever, that the kind of receiver just went quiet on it. And the people Trento have indicated that the receivers, and I'm putting this in as gentle language as I can, the receiver has not been overly aggressive in pursuing a transaction with them. And it seems like the receiver has imposed and taken a view of reviewing this transaction, being the Trento transaction, in a different way than it reviewed the prior AIversity transaction. In essence, and this is not, I'm not quoting anybody, but the way I saw it is, if they said yes to AIversity in 20 minutes, here we are a week later, and they're still, commenting on the I's versus the J's, that the scrutiny is much more, and no specific reason for that. And I don't know if it relates to the third choice, and I don't know if it relates to some other purpose that the receiver has. I do not know. Again, there's no reason I feel uncomfortable with the receiver at this point in time. I don't know anything specific, but just in general, I have a lot of questions that remain unanswered. So all I know is I saw a proof of funds. He's saying bona fide. That seems like a subjective characterization. I mean, anybody could say that something's not bona fide because you don't like the bank, because you don't like where the money's coming from. Does that make it not bona fide? I mean, if the check will cash, if the wire will cash, doesn't that make it bona fide? So I kind of think the use of the term bona fide is kind of like a subjective BS term, but I don't know what the forensic, because again, without being specific, and I don't know why they're disclosing all this when they have many times expressed concern about giving out this information because it might affect the stock price. But here they are. They wouldn't even give the status of the audit because they claimed it would impact the stock price. Here they are giving out. I haven't heard about Korean Investment Holding Company. They haven't provided any kind of written agreement. They say it's a verbal non-binding. So why are they disclosing that now? Why is disclosing that offer when it might affect stock prices? When in the past they claim that they're not going to be disclosing information about the status of the audit, for example, because it might impact stock prices and somebody might be able to trade it. I think that's somewhat inconsistent, may not be significant, but it's certainly inconsistent, like a lot of things that I think are inconsistent about the handling of things. So the third entity they claim that, and again, they claim that they did not have bona fide proof of funds. They didn't say that, by the way, that proof of funds had not been provided. They just said they have doubts. Their forensic review raises doubts. I don't know what kind of review that was. I don't know who did that review. I don't know who paid for that review. But anyway, the third one is Korean Investment Holding Company. I don't know what that is. A Korean holding company conveyed a verbal, non-binding commitment to fund the audit and take control, merging in a portfolio company with expected 2026 revenue of approximately $13 million. Now, the fact that a company might have $13 million on revenue, what happens if it costs $50 million to produce that 13 million? And this is expected revenue. We don't know what that is. And again, isn't this basically the receiver giving the company apparently to a Korean holding company that he doesn't know or doesn't indicate what it does? in order to get the audit done because he doesn't have the funds remaining to do the audit? Isn't that kind of the bottom line? And if he doesn't have the funds to do the audit, whose responsibility is it that they don't have the funds to do the audit? And I'm going to get to an issue that will kind of go along that. He says, he's talking about a verbal. So he has written documents from the first and the second. He has proof of funds, which he claims is not bona fide. He says this one, the third one, is tractive, despite the fact it's a verbal, non-binding commitment to basically fund the audit and take over with expected revenue of $13 million, but we don't know what the cost and the downside will be. We don't know what the dilution will be. We don't know anything. And somehow this track is attractive because it funds current reporting. So in essence, it pays because the receiver has mismanaged the audit process. And again, this is my opinion, because the receiver has mismanaged the audit process. And even though in court, he indicated that there was a source, sound like where he could borrow, not give away the company to get the audit done. But so here he says he'll fund the auditing and introduce an operating business. With what kind of operating business? He hasn't defined it at all. And it's a holding company. It's not a business, not an operating company. We don't know what its contents. We don't know what its liabilities are. And again, it certainly could be a losing company. But I just find it hysterical that he's saying that this sounds better, even though it's verbal and non-binding, compared to two written documents, which they quibble about, maybe correctly, but they quibble about. So the decision-making or his reference doesn't give me any extra calm that he's making a proper decision. There's some other stuff in there, but I'm going to now go to the report itself, or just like little bits and pieces of it. It says that, basically that I'm looking at page 8 of 25. So this is one of the shortest reports, again, probably to save money, is my guess. Because there's probably a big receivable owed to to counsel. So there's a reference, the heart of receivership is that the CEO, Reichman, caused the company to disperse, transfer, or otherwise misappropriate millions of dollars of corporate cash and stock for the personal benefit of himself and his daughter, Justine Reichman, with the assistance of Kathy Griffin, various professionals, and others. And basically 2 categories: misappropriation of corporate cash and issuance and laundering of GTII stock to affiliates. Stop. Despite that, the receivership is trying to cut deals with those very people being Mr. Reichman and Justine Reichman. And why they should be cutting deals with those people, especially if they're going to be pursuing, or they say they're pursuing actions against them, I don't understand. It makes no sense to me. Again, I understand why you cut deals in general, but again, Bernie Madoff did not get a deal. And the receiver, in his 7 reports and the summation, claims, I just read it, what he claimed, a huge misappropriation of cash and of stock for personal benefit of himself and his daughter. And as a matter of fact, I've had a running battle with the receiver's counsel, and also with the plaintiff's counsel. I didn't understand why the receiver never went after Justine Reichman's home in Lakespur. They never filed a lis pendens, never filed a lawsuit. She's still not a party to this action. They claim that she and her companies, this is what the receiver claims, she and her company got all kinds of shares, sold a bunch of shares to generate millions of dollars to buy the home in Larkspur. I know that you could have filed a lawsuit and recorded the lis pendens. Worst case scenario, you would lose the lis pendens, but the lawsuit would remain. What happens if you lose the lis pendens? You're obligated to pay the legal fees the other side, just for that particular proceeding, not for the entire case. So it's chump change. And I, on multiple occasions, I won. I talked it out on multiple videos, but I also addressed it directly with the receiver's counsel. and to plaintiffs' counsel. And it makes no sense still to this day why they gave Justine Reichman a free ride and didn't go after her property, didn't try to push that, because everybody knew, and the philosophy was that was a weak spot for the prior management, and that would encourage them to capitulate. And we're 2 years later, and they still haven't capitulated. The receiver's counsel's choice about not pressing Justine, I think, has led us to be 2 years later, and they haven't capitulated. I think it was a wrong decision. I've referenced it many times. I didn't hear any good reason for not doing it as of today. And I heard the receivership's counsel's explanation, and I thought it was, I just didn't agree. So that's that. And then we talk about the condo. So one of the items that they're talking about some of the items in the report. I'm looking at page 9. The report, they talk about some of the items that they used to acquire using funds through GTII or associated with GTII. And one of the things they do is the Wilshire Boulevard unit 1103 100560 Wilshire Boulevard in LA. That he bought for $1.4 million and spent a bunch of money refurbishing it. I have no idea what it's worth today. But apparently, they generated millions through various schemes. I guess $400,000 was to do a build out there at that unit. The other residents, apparently they used $1.3 million, or no, it says $2.5 million to buy the home there. And they don't explain though why they didn't take any action. But in paragraph 26, they acknowledge that there were the Lake Spur residence, which is Justine Reichman's residence, that the money came theoretically through GTII, but they elected not to pursue the home. I don't understand why. It doesn't make any sense. I think it was a mistake. And again, when I'm saying this, is not like me saying this for the first time. I certainly not right all the time, maybe not most of the time, but on this one, I've been right all along. And so when I thought it was a weak strategy from the start. I didn't understand it. I still don't. So, but that doesn't mean, by the way, there's anything illicit or whatever. I just think it was a bad decision. And that's what I expressed and still express. They talk about all the stock laundering, and they talk about, the money coming in. They talk about the 8 million shares from Dot 8, which was Justine Reichman's company. They come to the conclusion, and again, this would support my asking them to go after her from the start. But on page 11 of 25 of this report, on the receiver's analysis, Justine Reichman or persons controlling her accounts sold GTII stock aggregating in the millions of dollars, and she was the single largest beneficiary of illicit self-dealing. This is what the receiver says. I had suggested they vigorously pursue her. I don't mean like in negotiations, vigorously pursue her, tie up her home, tie up her assets, make her hire counsel, file a lawsuit against her, put her to the screws because it's justified because of the conduct. As of this day, they still haven't made no sense as to why they haven't do it. Paragraph 31, also on page 11, they talk about an attorney, Mark Richardson, who apparently was involved in stock laundering, according to the receiver on this report. He issued a bunch of shares, then sold like $3.5 million in stock between 21 and 2023, with 90% of that going to David Reichman, and the rest going into his pocket, $561,000. I mean, that can't be appropriate or proper. And the proceeds, that $3.115 million, those proceeds, according to the receiver, went to the Wilshire condominium and the Lake Spur residence. If those proceeds went in there, and again, this makes no sense to me. I think it makes the opposite conclusion true. Then why didn't they file a lis pendens and go after that property? Why did they let it sit? Doesn't make sense to me. And then they talk about the Markowitz transaction, paragraph 32, where there's some kind of stock sale, goes to like a third party into a different account, and it goes zings across the world, comes back. $1.8 million apparently goes to Reichman, and 200 grand I think goes to Markowitz. So obviously that's inappropriate also. They talk about briefly about the short selling stuff, and they blame everybody else again for the delay in doing it. They asked for documents. They got documents in April. They are moving forward, but again, my view is that they're moving forward at a snail's pace. Now here we come to something that's in it, and I'm going to address how they characterize the audit. But this is, I'm going to take a sip. This was, I either forgot this, or I didn't remember it, or it wasn't disclosed. And I don't really know which one. But paragraph 46, page 17 of 25, they disclosed that on November 1, 2024, the receiver loaned $100,000 to MSC Capital Advisors LLC with a property participation feature capping obligation at 200 grand. MSC defaulted. It repaid $55,000. Now it reassigns something else. We don't know how much, by the way, in legal fees were attributable to this, but I don't know why. I don't know who MSC Capital Advisors LLC is. If this was a loan to them, I don't understand why the receivership would be loaning $100,000 to MSC Capital Advisors a month after the receivership was set up. Why would they be giving money to them? And they didn't pay it back. So we know that the receivership is out of money. So the receivership loan has further exacerbated that problem. Theoretically, we don't know how much in legal fees has also been incurred and paid. We don't know how much time the receiver has spent on this, which should have been allocated elsewhere. So we don't know how much that has shorted the receivership estate, the GTII estate, from money. But I don't know why. So apparently what happened is in April, and I saw this recently, in April, apparently they did make a filing. I don't think they filed, at least I haven't seen an SEC filing, or I'm not aware of an SEC filing. If there is one, please let me know, of a loan from the receivership to MSC Capital Advisors LLC, November 1, 2024. But I don't know why they'd be loaning money. I don't know what the rationale would be. And if we're short cash to do the receivership, to do the audit, then the receiver should find a way to get the money, not by selling out to some, I guess, Korean, we don't even know, it could be a North Korean holding company. He should get it done, and he should take responsibility for the fact it's not done, as opposed to passing on. So what happened was apparently a recording where they got an assignment of some other notes, and they're going to go after these other notes. But it sounds like, that was a bad loan why should the receivership be making loans? It doesn't make sense to me why the receivership should be making loans. We're not a bank. And I have concerns about that, and I will raise the concerns to the court. And I also asked receivership counsel, after I saw this, I sent them an email asking for an explanation about this. When I get an explanation, I will let you know. But it seems kind of squirrely. Maybe it's perfectly legit, but it seems kind of squirrely. I don't understand why they'd be giving money to somebody else. It's not their money, really, not their money to give, unless it's for a purpose involving the receivership, which didn't seem to be, at least as far as I could tell, didn't seem to be. So kind of makes me concerned, to be honest. Maybe it's nothing, but it causes me to be concerned. And it's interesting they disclosed it, and maybe they disclosed it in other reports too. I don't know. Maybe it's been in there and I just missed it. That's possible. But when I looked at it and I thought about today, it with the delays, etc. When it talks about the audit, it talks about it's paramount purpose is getting it done, and it again, it focuses on, now I'm looking paragraph 49 on page 17 of 25, the audit history of the company. It predates the receivership because Chisholm, Beerwall, etc., got their registration revoked in 2011. Then it was Heaton and Company for the year 2021. I don't know what happened between 2011 and 2021, or that they did work during that period. And then BF Borgers for year 2022, and the enforcement action was 2024, etc. And then Fortune, and they claim that, you know, basically was hired by the other people, even though they elected to keep them. And then Barton. Now, what's interesting to me is, one, what happened between 2011 and 2021? Who is doing the work? If in light of the history, I would think you'd want to be a little more more concerned about what was going on. Fortune was retained by them. Borgers, we have the history about the first, the second, not getting done. They kind of skipped that. Now we get to paragraph 50. Barton's resignation, page 18 of 25. The single most material development since the sixth interim report was the resignation of Barton, effective April 15th, 2026. They basically don't identify anything of problem. They filed an 8K, although again, the question is, did they file an 8K when they hired them? I don't believe so, but they could have, just haven't seen it. They say at the time of resignation, the financial statements were substantially completed, not complete. Did they make a misstatement? As of September 1, 2025, with the principal open item being the accounting treatment of the GTI gold transaction and its associated debt, which requires derecognition, a final non-appealable and retroactive court order, a creditor release, or payment. I don't know what it does, but a lot of things. But obviously, that's something they could have discovered a year ago, a year and a half ago, if that was the only issue. Why didn't they know this before? Why didn't Barton tell them? Why didn't they ask? Why did they say that in open court, that there were hundreds, I think more than 1,000, less than 2,000 transactions that were an issue, where the receiver literally asked the judge to look at him in camera in his chambers, not in front of anybody else. I saw that. So I don't know what he's talking about. Successor auditor, this is paragraph 51. The receiver moved immediately to engage a successor and received 2 fee quantified proposals, Integrit and Weinberg and Company. As set out in section F, the receiver intends to retain Integrit to complete the audit and bring the company current at a proposal of approximately $200,000. Remember, that's without the 2022 audit, which was done by Borgers. And how could you rely upon anything that Borgers did? Because it's garbage, because they were shut down and they were making up work papers. That was kind of their history. The existing work product, trial balances, general ledgers, source of funds analysis, and Barton work papers means the successor is not starting from scratch. Maybe they're not starting from scratch, but originally the receiver said they can complete both audits and the 2024 audit in 120 days. I heard that too. And again, anybody who listens to these hearings, please correct me if I'm wrong, but I heard that in the hearings. So it's whatever. So it wasn't like they're now asking for permission to hire them. They already granted permission. They already said they hadn't gotten an engagement letter. So I don't know what this is talking about. Again, it seems like to me, either it's inaccurate, best case, or it's a distortion trying to lead the new court to believe that they just started trying to get these new auditors, when we know that it's been a process, a process. And as I represented to you in the declaration, not disputed, they went through that. This guy had a great relationship with Integra 2 years before and whatever. They just didn't deal with it. Another thing, I guess they can't deny that. The problem is, so everything I'm indicating where they haven't addressed it means that they probably can't deny what I said. They're just not addressing it. So is that technically not being truthful? No, but it's certainly not being transparent. It's certainly not presenting evidence that might not look, good to your client. So they say that basically they're seeking approval to be able to hire Integrit when they were already given approval, and they already said they had missed the opportunity to get an engagement letter. Then they go through the path, whatever. They talk about the claims process. They refer in paragraph 60. They now claim that that's a matter of just bringing the delinquent stuff current, but they say now they don't need a 2022 PCAOB qualified audit, and that 2025 has been reconstructed on a cash basis, unaudited from bank records. Following Barton's resignation, the receiver intends to retain. So here again, this is I would say presenting it in a false light. They intend to retain. We already heard the story that they had already decided to, but hadn't gotten an engagement letter. This engagement, and this is what he says in that regard, page 21 to 25. This engagement is an administrative obligation on the critical path to becoming current and is contemplated to be funded at the estate level. I have no idea what that means. They say that they're investigating causes of action and they might pursue RICO claims because of the large defalcations, which means basically a theft, and 178 million shares or so. Pending deals, they talk about the 3 deals, as I mentioned before. And they seem, although it's an oral, non-binding, without identification, without a business, but because they'll pay for the audit, apparently, although that's not referenced in clear. And why, if they're going to pay for the audit, then we might as well get the 2022 and the 2025. Why not do it right, not do it the way that's been done in the past? That also bothers me, that the in light of the history of the accounting problems in this company, that the receiver still wants to cut corners and not do the work that needs to be done. That is concerning. That really is concerning. Anyway, says that's great. He said they basically end the report by saying, we're not asking for anything. We're just kind of bringing you up to speed. And the conclusion is on page 23 of 25, for nearly 2 years, the receiver has stabilized GTII, conducted an exhaustive forensic investigation, marshaled substantial cash and share recoveries, concluded numerous settlements, advanced the company's audit towards completion. Stop. That is just utter BS. Advance the company's audit towards completion, where he represented to be done in 30 days. That is just outright nonsense. And again, I'm gonna be focused on some of these items because I'm gonna definitely do a responsive filing to this. I just think a lot of it is not accurate, and I'm going to be pointing it out to the court. And I don't know why it's not accurate. Is it either just inadvertent mistakes, or is it intentionally trying to misdirect what's going on? But it really pisses me off, like statement like that. Advance the company's audit towards completion. That really infuriates me. And develop multiple paths to restore GTI to lawful, current, and value generating public company. I haven't seen anything. And the one he promotes is an oral, non-binding, without anything, knowing nothing, because there's no cash to do the audit, because they've used the cash on what, including loaning money out. The receiver respectfully submits the consolidated report to Orient. So that's kind of the end of it. Dated July 17th, which was Friday. Now, again, it coincides with my report my declaration I filed, and the live stream we did, a couple of live streams we all did, and that's kind of bringing us up today. So that's what it says. If any of you where I was making points about what I heard in court, if any of you agree with that, disagree with that, please comment or let me or Renee know about it, and we can go from there. But obviously, we're going to be I will be responding to this and filing something with the court that tries to kind of clarify perhaps some uncertainties that have been raised in light of this particular report. And if you have any other comments, please let me know. Thanks for hanging out on this Saturday. Hope everybody is well. And obviously, I'll keep you apprised. And as we get more details, I'll keep you in the know. And that's it for today. So I'll see you later. Have a great afternoon. Drink a glass of wine